No? Anybody?
Are we talking impaired or incapacitated?
It doesn't matter. Whatever one, right? How many of you have been a little bit in the last 6 months? How many of you have drank to the point where you might not have been with your full brain? Okay? So, you can't consent if you don't have a brain. So, interesting fact situation, okay? Let's say that guy at the bar, pretty drunk. Woman at the bar, pretty drunk. And they end up waking up going, where the hell am I? Ah! Like this, right? Any torts there? Presuming physical contact, what tort? Against who? So how many torts is there? There are 2. And they don't cancel, right? You don't go, you got 1, I got 1, I guess we got 0, right? They don't cancel each other out. There are 2 batteries. And the way that that would have to get resolved is by determining who had the greater loss. Who had the greater loss? I really didn't enjoy that. Well, I didn't enjoy that even more than you didn't enjoy it. I thought that I'm feeling a little humiliated. You're humiliated. I am terribly humiliated. I'm more like, who has the loss there, folks? I don't know. But you get 2 drunks, you get 2 batteries. Because neither of them can consent. Because they don't have a brain. All right, I'd like to take a break now. I'd like you to be back here at 25:02 if you can. For those people who arrive late, I will take 2 minutes to show you how to fill out the small claims form because it's going to be on the desk. I'm just going to give you a little warning in terms of making sure that you don't ever get confused. You will probably not on a daily basis run into the rules for suing. They're not things that you hear about in the news. They're not things you hear about in most situations you're dealing with. Lawsuits are not things that you will probably be running into on a regular basis. What you will sometimes run into on a regular basis is crimes. You see them on the news and everything else. You cannot use the rules for crimes when it comes to suing people. They're not the same rules. So this is why I say everything you need in this course, I will give to you. If you need it, I will give it to you. And if I haven't given it to you, I don't want you using it. Okay? Does that make sense? So we're going to walk you through the rest of these defenses. So consent, you have to understand the difference between actual and implicit. You have to understand that actual must be informed. You have to understand that implicit can be because of course of actions or history or societal norms. But you also have to understand that you cannot have implicit consent if it's been expressly removed. If someone says no, even though there was implicit consent, that consent is no good. And you have to have a brain. Go ahead.
What if the intoxicated person is passed out and can't give consent? Would you still go over the fact that they don't have a brain, or would you use a societal norm?
If you're drawing something on their forehead,
But as a medical kind of thing like that.
so how many of you have done that? Draw something on the forehead when people were passed out or seen it done? How many of you have seen this done? Put up your hands if you're familiar with this exercise of putting things on people's foreheads when they're passed out. So when they go down for breakfast, because they don't look at their face because they're all hung over, and they sit down for breakfast with their mom, they have a penis on their forehead, right? Right? The things that we do, right? Anyways, that type of thing, you could almost make the argument that, hey, and I know this isn't quite answering your question, but I want to use it at this point in time. That's a societal norm. When you pass out in Canada, you get things drawn on your forehead, okay? That is not, right? That's not what we're talking about. But if you have someone that is passed out, I mean, this happens all the time with these horrible drugs, right? Where people are on the verge of death, right? And they've got to do something with them. The societal norm is what would be used for saving them.
So trumps that in like a medical?
Yeah, but if I'm unconscious, I don't have a brain either, right? Like if I go because I'm in a car accident, the reason why I'm unconscious becomes irrelevant. It could be because I've drank. It could be because I've got a drug. It could be because I'm having a seizure. It could be because there's a medical. It could be lots of things. So in that situation, the societal norm would give implicit consent in all of those situations. But not for you to draw things on people's foreheads, okay? There's no implicit consent for that. Any other questions? Go ahead.
Let's do the second circumstance for the consent. The first circumstance was implied history. The second circumstance in which implied consent.
So implicit consent normally arises from two things. One, a history, and the other, a societal norm. The history is your wife giving you a kiss on the cheek, okay? She's done it 100 times. She can presume that you're okay with that, okay? The societal norm is somebody who's gone to a hospital. In other words, there is no history, but we know it's that they want to have their life saved. I always think of the Aladdin film. I imagine most of you are too young for that, but there's a scene in the Aladdin film where he's got to use his last wish, but he's unconscious. I don't know if you guys remember that, right? And they said, "Do you want to use your wish?" You got to say yes, and then they go. The guy makes his head go, and they say, "Okay, I will." Right? That would be covered by implicit consent if it was a legal situation. Got it? Consent's a little tricky, folks. Second defense, and these are general defenses. In other words, if you can make the facts fit, if they fit, it doesn't matter which of these torts you're dealing with. They can always be used. That's the way that general defenses work. Some of them, though, are more likely to be tied to one of these torts. And this is one of them. It's self-defense. You can defend yourself from harm. So it normally is a defense to someone who is being sued for battery. And they said, "I hit you because I was defending myself from harm from you." Right? So the rule is very simple. You can use force or commit a tort to defend yourself from harm as long as what you do is not obviously excessive. So, if I'm going over to punch him in the shoulder and he pulls out a gun and shoots me, is that obviously excessive? Is it obviously excessive? Thank you. I'm glad you all agree with that. Don't do that, okay? All right? That's obviously excessive. But what if you hear a noise and you go to the top of your stairs and there's some stranger coming up, right? And it looks like they've got a knife or a gun or something metal in their hand, and you pull out your gun and shoot them. Is that obviously excessive? I will guarantee if you did that, you would get charged with murder. In Canada, you would get charged with murder. But if you get sued for it, the test is it obviously excessive? And what the court has said is that, look, if he's coming at me, I don't have to sit here and calculate exactly what I have to do, how much force I've got to use to make sure that he doesn't hurt me. I don't have to figure that out, get just this amount and not this amount and this amount. I don't have to figure that out. I just can't be over the top. So if he's coming at me in a rage and I break his leg, is that obviously excessive? So the test isn't could you have done less. The test is what you did obviously excessive. This third defense, and that's all there is for that one, is defense of property. You can commit a tort to defend your property as long as what you do is not obviously excessive. So if you go out at 2 a.m. and you notice that somebody's loading your quad in the back of their truck to take off with it, can you shoot them? Is that obviously excessive? Yeah. Can you shoot their tire?
Yes.
And what if you miss? Well, now you might be negligent. All right? So, you can take steps to defend your property as long as the force you use is not obviously excessive. And at this point in time, I need to make something else clear, okay? Because people will... I get asked when I teach this thing, it says, what about this? What about this? What about this? What about this? Right? People saying, what if this happened? What would be the answer? That's not what we're doing here. I cannot tell you what a judge will say any better than you. What I'm telling you is, that's the question. And you have as good of ability to answer that question as I. What I'm asking you is, make sure you ask the right question. If you ask the right question, then your answer is an opinion, right? So, I'm not teaching you what the answers are. There aren't answers. I'm teaching you how do you get there. And what this allows you to do is in real life, you'll know facts, you'll know the questions, and you'll be able to evaluate how likely it is that that law will get applied into the facts. But you have no guarantee, right? The judge may interpret the facts different, interpret the law different. They could do. You have no idea what they're going to do. I'm trying to teach you how to assess situations without actually getting an answer. You can't get an answer. You don't know. The only way you're ever going to know is if it goes to court and the judge tells you what the answer is. So, but you at least have an idea of what would be important in determining that. So, when students start asking me, what about this, I always tell them the same thing. You tell me what you think it is, because your opinion's as good as mine. I tell you what the question is, and then it's whatever your answer is just as good as mine, as long as you're asking the right question. So the question here is, was the tort, what the person did, that's the defendant, no, what the defendant did, go through this, obviously excessive? If it is, then they may not have that defense. The fourth one is called lawful authority. There's a law that lets the person commit the tort. So that's my example with Raylene. With Raylene, the law, there's a section of the criminal code that says police can come and arrest and detain you if certain things have happened. And they've come and done that. You sue them, you're going to lose because they've got the lawful authority. So lawful authority either comes from statute, where there's a rule that says that they can do things. It can also come from contract. So if you buy a car and you say, if I don't pay for it, you can come and take my car. So they're making off with your car. You're going, hey, you're touching my personal property. That's conversion, and it is. But the defense is, you signed a contract, gave us the lawful authority to do it, we got the legal right to do it, and that becomes a defense. One of my favorites is the fifth one. It's called necessity. Necessity is an equation. You always have to weigh two things to determine whether or not this defense will be valid. And what you have to determine is the harm that was done versus the harm that was prevented. Okay? So, what's your name? Hamid still?
Yeah, it's somebody.
You still? Okay. If Hamid was to stand up here, okay, and he was standing right here and I was standing here, and suddenly I ran over and pushed him, knocked him right down, broke his leg, right? That sounds like what tort? Battery, right? But there was a bus coming. And if I hadn't pushed him out of the way, he would have died. So he sues me for the battery for pushing him. I used the defense of necessity. The harm that I did, which was pretty bad, but it would have been worse if I hadn't done it. The harm that I did was less than the harm I prevented. Another situation, same sort of defense, is you're traveling down a country road, your car gets stuck, it's 40 below, not like it's that cold over here. And the car runs out of gas, and you start to feel hypothermic, and you're not sure you're going to make it to morning, and you see a house, and you go crawling through the snow, and there's no one home, and you break the window, and you go inside and you warm up. Well, that tort would be, and the defense would be, yeah, the harm that I was preventing, which was death, is a lot more than the harm that I did, which was broke your window, right? That's the defense of necessity. It always requires you to weigh one versus the other. And the last defense is probably one of the most important ones in a lot of ways. There are time limits to sue. These are complicated. I don't teach you all the complicated rules in this course. You don't need to know them. What you do need to know is there's time limits. So the basic rule is that you have 2 years from the date that the incident occurred to the date you file in court. So you've got 2 years to do a statement of claim. That is for torts. For contracts, I'm going to mention this now, you have 6 years. From the date of the debt to the date of filing in court. So, if I was to push Hamid down there, I guess he's got until, what's the date today? 30th? January 30th of 2021. If he hasn't sued me, he probably can't. I say probably because in this course we're going to treat it as fairly firm, but there are ways that the times can get extended beyond the 2 years, and there are circumstances in which they're shortened a lot. I'll give you an example of that, or you don't have to remember it. I just want you to understand that these rules are not, it's always 2 years. Okay? If you want to sue a municipality, you have to have given them notice within 48 hours. And if you haven't, you lose your right to sue. ...48 hours, folks. So if you're if they spill water on the street and you're walking along and you slip and you crack your head and you break your neck and you're quadriplegic, if you haven't given them notice within 48 hours of your intention to sue, you lose it.
If you're unconscious.
Don't be. They're not firm rules, but the point is, these rules are very technical. They're very situation dependent. You can't say one size fits all. And this is why, if you're ever thinking of suing somebody, you need to contact a lawyer right away. The lawyer's job is to know these rules. That's not your job. Your job is to know that there's time limits. And with torts, it's 2 years, okay, generally. But you got to call them right away. And by the way, this is the number one reason that lawyers get sued. The number one reason is they miss a limitation period. They don't get the papers in time. The number one. And then you get to sue them for being negligent in not getting your papers in on time. And you'll win. It is the number one reason. You got those? In addition to these general defenses, there are also going to be defenses that are tied to the specific torts. So what I want to do tonight, and what I've put up on the board, and you can record these if you like, because at some point you're going to need them, but I am going to deal with them one at a time. So these are the elements for each tort. I guess the quiz is going to be, which one is which? Okay, you should be able to figure that out, but I will help you a little bit with respect to those. Okay, so we're going to deal with this. This is battery. If you're dealing with battery, you'll be writing out these 5 things. That is going to be what you do in step number 2. If you've got a battery, you're going to write out these things. This is what you write out. What you write about is questions, but I want to see these words here. Okay? Was it intentional? Was it wrongful offensive? Was there contact? Was it with a person? Was it without the consent? Even though consent is a defense, because it's such an important defense in battery, we've actually put it and we move it up to being in the elements. And in order for you to understand that, you have to understand the law I just taught you about consent. There's implicit, there's express, but it has to be neither of those in order for it to be battery. So, there is meaning behind each of these that you have to understand. And that what I'm going to do now is talk to you about some of the rules that clarify what each of these mean. What I'm giving you is information that will help you in certain circumstances tell if the law is going to say it's yes or no. So, let me go over here. Can I have your name? Jenna. Jenna? Is there a bunch of Jennas? I remember this. How many more Jennas? Okay. All right. So, let me show you this, okay? So let's say I walk up to Jenna and I say, that's terrible that you come here and have 2 people with the same name. And I give her a little smack on the head. Just a little touch. Just a little, not that hard, right? And what I don't know about Jenna is she has a rare medical condition. And her skull is not the normal thickness of a normal human being. And I give her that little whack. Basically, I crack her skull. It goes into her brain, causes her to have brain damage. And she sues me for damaging her brain. Did I mean to damage her brain? No. So, what we're dealing with is, what does this mean? My argument is going to be, I didn't mean to hurt her like that. That was not intentional, and therefore there is no... Right? You see the argument? Does it make sense to you? It won't work.
But it's not intentional.
You got to know what the law says that means, not what you sit with your crochet set and figure out what it means, okay? You got to understand what the rules are here. And this is a situation in which the law has gone in a direction that you might not think it would. Right? And that's why you need this stuff. You need more information than just what does this mean? I will figure it out by myself. So it's kind of like this is, and I don't like doing this, but it's kind of like this is statute law, right? And then we have to have common law to figure out what those mean, right? But the truth of the matter is, this is probably common law, and so are the rest of the rules in many of these situations. It's not like that. It's not actually common law and statute law, but it's like that. You have a rule, and then you have a meaning, right? So you go, oh, that's not a highway. A highway's up there. And I go, no, it's a road through a thoroughfare. Oh, okay, that's a highway, right? So you understand what that means. So this rule actually has a name, and it's got a name that's going to be easy to remember because it's actually called the thin skull rule. Thin skull rule. And it's because there was exactly that type of fact situation that happened. Somebody with a medical condition, their skull had not formed at normal thickness. Somebody punched them. It shouldn't have done a lot of damage, but because they had this, they had a lot of harm done to them, right? And they sued for the harm. The case was, that wasn't intentional. You can't get me for that harm because I didn't mean that harm. And the court said, you take your plaintiffs as you find them. If you intended to hit them, it does not matter that you did not intend to cause the harm. In other words, they say this relates to the contact, not the harm. We look at, did you intend to hit her? Which is what? Did I? Yeah. And you don't look at, did you intend the harm? And that rule is called the thin skull rule. It deals with what does intentional mean. It means intend to contact. It does not mean intent to harm. Okay? You understand that? Let me show you another law, okay? Let's say that Jenna smarts up because I go to hit her, and I miss. And I hit you. What's your name? Tash. I hit Tash. I meant to hit Jenna, but I didn't. I hit Tash. And Tash sues me. What am I going to say? I didn't even mean to hit you, Tash. Right? You are not the student I was looking for. That's my Star Wars reference. No one gets it anymore. All right. I didn't intend to hit you. You can sue me all along. You're going to lose because I didn't intend that. Do you see how that argument seems to make some sense? Right? You can understand why. And you need to know what the rule is. And the rule is intent can get transferred. The intention to hit Jenna is what she will use to prove the intention. Intention can be transferred from one person to another. So as long as I intended to hit her, she gets to use that intention to prove intention. And you will win. These are not the answers you might expect if you don't know what the law is. Next point that I want to make about this. I'm going to go over to this Jenna. So you hit your head and you're bleeding, and I go to give you a Band-Aid. Right? You said, I don't want that Band-Aid. I said, you need a Band-Aid. You're bleeding. You said, I don't want that Band-Aid. I'm putting the Band-Aid on you because you need it. You know, it's good for you. It'll help you. Right? And I put the Band-Aid on her. Is that a battery? Well, first of all, was it intentional?
Yes.
Okay, we're going to talk about how do you prove intention in a minute, but I'm going to talk. So, it deals with this. Is it wrongful or offensive? And the question that we're dealing with here is, to who? Whose perspective do we use on that? My perspective is, this is not wrongful or offensive, she needs it. Her perspective is, don't touch me. Do you see the issue here? We have an issue of whose viewpoint do we use on this? Hers or mine? It is. I can't say she needed a good smack and say, well, she needed that. She was hysterical. Okay? Or this is good for her. Or I'm giving you that medication whether you want it or not. Because it's wrongful or offensive to the plaintiff. It's their perspective that matters. I love this. I get to whack students all night long. Okay? So if I walk up and go, is that a battery? What if she's not hurt at all? And the question is, do we need injury?
No.
Not even close, right? The extent of the harm is a factor in how much she can sue for. So that type of battery would be worth almost nothing, right? $10. But people will sometimes say, well, it's only a battery if someone's hurt or injured or bleeding or bruised. And that's not true. What is required is contact, not harm, not injury. Spitting on someone doesn't cause them harm. It's still a battery. Giving a hug doesn't cause them harm. It's still a battery if they don't want it. And even if I'm a doctor and think that this is going to be helpful to them and they don't want it, it's still a battery. Because it's wrongful or offensive to the plaintiff. The person doesn't have to be conscious of the fact that they were contacted at the time. In other words, if they're unconscious and they don't find out, when they find out, it's still a battery. You can't say, well, you didn't even know I touched you. That's still a battery. And they might not find out for months, like 9 months. It's still a battery. However, the other rule you need to know is contact can be direct or indirect. So, if I walk over here and go, like this, did I contact her? Well, I didn't really contact her. I contacted her top, her shirt, right? And that's not a part of her, is it? So what if I go like this? Is that contact?
Yes.
It's because it can be direct or indirect. It doesn't have to be skin-to-skin contact. I could, if I throw this at him or shoot him with something, right? I haven't touched him at all, but the thing I'm using has touched them. That would be a battery, direct or indirect. What if it's going to happen? What if you get on a bus that's so crowded, people are going to bump into you? Can you say, "Don't touch me or I'll sue you"?
No.
No, it's inevitable. You know it. You get on that bus, people are going to run into you. You know it. You get on the bus, that's inevitable contact. What about playing hockey, folks? How many of you play hockey? Any of you played hockey in your life? How many of you played hockey? 1? Come on. 2, 3. That's it? So no one sitting in this section has ever had a hockey stick and skates on at the same time. Am I right about that? I didn't ask about soccer. I asked about hockey. Because soccer is different. I can't ask because it doesn't work. So, folks, the puck goes down into the corner. You skate down there, you grab the puck, but in comes 2 guys on the other team, and one of them is going to do what?
Check you.
Yeah, they're going to check you. Can you go, "Stop right there"? "You check me, and I'll sue you"? Can you do that? But there's a problem here if you think it through based on what I've told you. Which is what? Where's the consent to be touched? What? But isn't that implicit consent? What if you expressly remove it?
Better find out later.
So you'd have to show that that's actually express consent because the rules say this will happen and you've agreed to it, right? Otherwise, you can't implicitly remove it. There's actually a movie that is, I don't use this reference anymore because no one's seen it. Because I'm so frickin' old that I'm dealing with movies from the 90s, okay? Some of you weren't even born then. But it's called Stripes. It's a Bill Murray film. Everybody seen it?
Yeah.
Right? And remember Psycho? Yeah, the people that are more mature in the class, they've all seen it, right? It was a good movie, right? Right? Yeah. And then remember Psycho? And he has that famous classic. He says, "Any of you homos touch me, and I'll kill you," right? Well, you can't do that in situations of inevitable contact and say that that's taken away.